Hello, this is Matt on the Moon Lambo channel. The SEC continues to try to destroy Ripple and destroy XRP, and Pro-XRP attorney John Deaton has a fiery response to all of that nonsense, which I'm going to be sharing with you in this latest Moon Lambo Hot Jam. And I'm going to go ahead and recommend that this would be one where maybe you want to pop some popcorn, get your favorite treat. You can pause right here. I'll be right back when you get back. Kick your feet up, wiggle them toesy woesies, get all relaxed because this is going to be a fun one. John Deaton sharing his legal perspective on all of this stuff. It's always a good time. Now, I do want to be clear that I personally do not have a legal or financial background of any kind. I am not offering legal or financial advice, and you should not buy or sell anything because of anything I say or write. I'm just an enthusiast who enjoys making YouTube videos as a fun hobby about Ripple and XRP and crypto and asshats like Jay Clayton, and that is all that's going on here. Just want to be super duper clear. So John Deaton, he put out this new thread here, and wait till you see the way in which he just artfully rips apart every nonsensical thing that is happening with the SEC going after Ripple. And it just, as I was sitting here, like going through this initially, the first time I read through this, I would pause multiple times, and I'm just sitting here thinking like, oh my gosh, SEC folk, what are you doing? Jay Clayton specifically, like why going this viciously? Why did Jay Clayton specifically? Because he was running the SEC, and I get it. There are 5 people that had a vote, including other commissioners. 5 people got to vote on whether or not this was actually going to move forward in terms of the SEC actually litigating against Ripple. But Jay Clayton's at the helm of all this, right? Or he was, until he filed this on his last full day and then just exited. But I'm sitting here wondering, I'm like, okay, so Jay Clayton, like, what did XRP do to you? Did XRP break your heart? Seriously, was there some sort of terrible breakup, and now you're trying to get back at XRP, or is it something more sinister at play, something more insidious? Jay Clayton, I would like for you to show me on this doll where the bad XRP touched you. It's okay, let me know. Something has gone down. Something has gone down. So let's let John Deaton rip this to shreds. And it begins as follows. XRP holders versus SEC. Hester Peirce, who, by the way, is an SEC commissioner, was interviewed by Thinking Crypto. It's a YouTube channel, which is Pro-XRP. It's run by a guy named Tony. It's not an XRP-centric channel, but it's run by a guy that is certainly pro-XRP. So Hester was interviewed by Tony with Thinking Crypto and said that she was trying to get people at the SEC to stop thinking about the token as a security, but instead on how the token was being packaged and sold. I tweeted out in disbelief, saying, that's only been the law for 75 years. The Supreme Court in Howey didn't conclude that the oranges were securities, but it was the scheme and the totality of circumstances surrounding the transactions between the parties that was held to be an investment contract. But it's not just the Howey case that has made it crystal clear that the token itself is not a security. Bitcoin, ETH, XRP, gold, soybeans, copper, coffee, and any other product or commodity can be marketed, packaged, sold, and distributed as part of an investment contract. Now think about that. And this is legally actually absolutely correct what he's saying. Anything can be sold as though it were an investment contract, which would make it a securities transaction, right? That means that it could be true. Like, even though Bitcoin, it got the verbal passes. John Deaton covers this in this thread, so I'll let him speak in his own words too. But I do want to say, like, even Bitcoin could be sold in such a way that it could represent an investment contract, even if Bitcoin itself isn't. So then why, knowing for sure that is the case, how could it possibly be that the SEC is claiming that today XRP itself is a security? That is absolutely Looney Tunes nonsense bullcrap. Now, the SEC enforcement lawyers have relied on and referred to the recent Telegram case as an example for the Southern District New York Court to follow. I agree. At Crypto Law US, which, by the way, is a website that John Deaton set up, crypto-law.us. Go ahead and check it out. The Twitter handle is at CryptoLawUS. And so he's citing this. Crypto Law US has uploaded for your review the 2 opinions and orders entered by Judge Castell in the Telegram case, and I encourage you to read them. After reading Telegram 1 and 2, you will get even more pissed off at what the SEC refuses to acknowledge. Remember, in Telegram, the SEC sought a preliminary injunction and won, preventing Telegram from using the funds raised by selling grams, that's the token, grams, to build the TON blockchain, TON blockchain. Telegram was very much like Vitalik Buterin's initial fundraising scheme. And so for those of you that are new to crypto, Vitalik Buterin, he is the guy, one of the guys that founded Ethereum, right? Which is the #2 cryptocurrency by market cap. And so Telegram was a pure ICO scheme. And again, as John cited here, very much like Vitalik Buterin's initial fundraising scheme for Ethereum. So Telegram was a pure ICO scheme. As the court found, the grams were sold to venture capitalists and high net worth individuals or hedge funds. And then he shared this tweet from fellow XRP YouTuber Digital Asset Investor, who wrote the following. According to the SEC, any information regarding how they gave the Ethereum fundraiser a free pass is not relevant to now going after Ripple? How about that? Yes, of course it's relevant. How the hell could it be that the details surrounding how the Ethereum Foundation, and everyone involved in initially selling Ether, how does that get a free pass? But then Ripple doesn't and Telegram didn't? The logic doesn't follow, which is why this is also infuriating. It's one of a cajillion reasons as to why. John continues now. Would be like comparing oranges to soccer balls to footballs. Let's review excerpts from the Telegram case, which the SEC loves to compare against Ripple. Maybe the SEC, and actually here, let me pull this up, maybe I know this. Security in this case is not simply the gram, which is, well actually just that's the important part, a little more than alphanumeric cryptographic secrets. How he refers to an investment contract, i.e. a security, as a contract, transaction, or scheme, using the term scheme in a descriptive, not pejorative sense. And then John continues, maybe the SEC disagrees and that decision isn't clear enough to help Hester Peirce convince her fellow commissioners and prosecutors that the token itself is not the security. If unclear, they should read Judge Castell's second opinion and order in the Telegram case. And then Castell, from the same SDNY, mind you, Southern District, New York, as Judge Torres, made it more clear, and here's a quote, that the security was neither the gram purchase agreement nor the gram, so again, that's the token, but the entire scheme that comprised the gram purchase agreements and the accompanying understandings and undertakings made by Telegram, end quote. So again, clearly, it's made clear. It's not the gram in and of itself that makes it a security. It's the totality of everything. And John continues now. Yep, that's right. In Telegram, there was an actual purchase agreement that the investor signed. A contract equal to half of the phrase investment contract. Castell said that the actual agreement itself wasn't a security, let alone the mere alphanumeric code, which was the gram. But the SEC refuses to acknowledge what the law is. I've made it clear from day one that I'm not a securities law expert, but I can read. The SEC keeps making a big deal about speculative investing. I encourage them to reread Howey, the very next sentence following the test. And so take a look at this. This is the screen grab, and I want to. It's what's highlighted on your screen. This is the part I want to read. Check this out. The test. We're talking about the Howey test. The test is whether the scheme involves an investment of money in a common enterprise with profits to come solely from the efforts of others. If that test be satisfied, it is immaterial whether the enterprise is speculative or non-speculative, or whether there is a sale of property with or without intrinsic value. Now, part of the reason that is crucial is because the SEC is claiming, the SEC lawyers are actually arguing that the reason that John Deaton and XRP holders want XRP to be declared not a security, but put back on exchanges, is purely to speculate, and that the speculation in and of itself makes it a security somehow. That it's completely illogical. It's completely in contradiction to what existing law would have any rational human belief. And here it is. It's right in front of you on your screen. Freaking Jay Clayton, what an asshat. Anyway, John Deaton continues. Considering that the SEC was specifically warned by Grunfest that the exchanges, by the way, so that's a former SEC chairman. I believe his first name was Joseph. I believe it's Joseph Grunfest. So considering that the SEC was specifically warned by Grunfest that the exchanges would delist or suspend XRP, the SEC could have made it clear to the exchanges that it wasn't claiming XRP the token was a security per se. They refused. Think about that. They absolutely could have. There's enough law out there to be certain of that, frankly. And they didn't care. They had no interest in protecting the XRP investor. And their mission is to protect investors. This is repulsive, what they've done. They harmed investors the way that they went after this. And we're supposed to thank them for this and have respect for them the way that they've behaved here? I don't know about you, but I don't feel any safer. I don't feel protected by the SEC. I don't need them to hold my hand. I can make my own damn investments on top of that. But even if I were an idiot, like, I deserve to lose my money then, right? If this is a bad idea, what I'm doing in putting money into XRP, then I deserve to lose money. Like, I don't need the SEC jumping in and just being a blockade in this manner. But even if we're going to accept that that's the right thing for a government to do, you're still outside of the scope of the law. And they have to know this. They're not stupid. It's my best guess. I mean, it could be a few things. It could be a power grab and or a money grab, or there's something behind the scenes that we're just unaware of, which is why I just think we need to hand a doll to Jay Clayton and ask where the bad XRP touched him. I think that might solve the problem. If we could just get to that, then we could stop all this crap and just get to the core of the issue. Anyway, John continues now. When we filed our writ of mandamus, they could have come out and made it clear they refused. Instead, they blamed the exchanges. When Judge Netbrin told the SEC lawyer that according to his argument, every person in the world selling XRP was in violation of Section 5 of the Securities Act, they could have made it clear. They didn't. Instead, they claimed Section 4 exclusions would likely apply. But Section 4 only applies if it's a security. When we filed our pre-motion letter regarding intervention, the SEC, in its reply letter, could have made it clear that it isn't claiming that our XRP is a security. They refused. Instead, they claimed sovereign immunity against us, called us speculative investors, which they claimed proves Ripple sold securities. And then he writes in parentheses, still trying to figure out what that nonsensical sentence means. Exactly. And so that's what I was bitching about a minute ago. The fact that there's speculation means that Ripple sold securities and that XRP is a security. The logic does not follow, but this is what they're claiming. Now John continues. There we go. Ripple sold, so they're saying Ripple misled the court by claiming that I said if we get XRP relisted, the price will double and then we can sell for a profit. In parentheses, he writes, I've already proven that's a lie. In parentheses, he continues then, and again blamed the exchanges. The law is clear. In 1946, it was made clear in Howey. In 2020, this time last year, it was made clear in Telegram. The SEC cannot in good faith claim that the token XRP is inherently an investment contract and thus a security. They can try and claim that when Ripple sold or distributed XRP at specific times, it constituted an investment contract. But at least acknowledge the law and quit focusing on winning the case at all costs. Maybe, just maybe, the SEC could also start focusing on protecting investors and users of XRP. Until that happens, the SEC will continue to be on trial. And then he looked at this piece from Forbes, which I already thoroughly covered, so I'm not going to do that in this video, but it was, I'll tell you what, that piece from Forbes was a straight up banger. It was a solid piece written by, what's the woman's name? Rosalind Layton, I want to say. And my gosh, she did an excellent job just ripping to shreds what the SEC has been doing. And it's just so fascinating to see the more and more time passes, the more it seems like a Ripple victory is inevitable. And when I say victory, specifically what I'm referring to is Ripple being able to function as a business, having a path forward to sell their XRP holdings, XRP not being listed on exchange. What I'm not including in that would be a situation where Ripple rather doesn't have to pay any sort of fines. I'm anticipating that they're going to have to, whether this is fully adjudicated or there's a settlement. I'm assuming something like that's going to happen just so we can get past all of this stuff here. And so even if that's technically a win for the SEC, I don't consider it a win in the grand scheme of things. That would be a win for Ripple as long as they can continue to sell the XRP, because they need to be able to do that in order to manage XRP via on-demand liquidity. That's crucial to the business model and as a funding mechanism. And then on top of that, just speculators being able to buy and sell. And there's so many people out there using XRP for all sorts of different things. If that were just straight up outlawed in the United States, I would be infuriated. I'd just be absolutely disgusted. And I don't think that's going to happen. But that's part of what's at stake here. So I thought it was an awesome thread, and I thought you guys would enjoy hearing it. So let me know what you think about what John Deaton had to say below. And be sure to give him a follow on Twitter if you've not yet done so, but I'll wrap up there. I am not a financial advisor. Do not buy or sell anything, because if anything I say are right, that would be a very, very, very bad idea. Until next time, to the moon, Lambo.